Well, good morning again, and a big thank you to Wendy and Wisconsin Farm Bureau for letting me join your Lunch and Learn today and share a little bit about farmland leasing and some other legal options for improving land access. You'll probably notice I've got a little note on here. Don't forget, if you're interested in taking notes, grab a pen and paper. Usually when we're in person, I try to provide handouts. Little trickier when we're virtual. So grab a pen and paper now if you don't have them. Let's see if I can get this to advance. I thought we had it. There we go. I do always like to start out with extensions commitment to accessibility. So if you do need any accommodations, let Wendy or I know, and we will try to make that happen. I also like to throw out there, Wendy mentioned, if you have questions as we go, drop those in the chat. You can hopefully see the chat button on the bottom of your screen. I'll give you a heads up that I can't see those chats right now, so I'm going to ask Wendy to sort of monitor them or let me know if there are questions there, or we'll circle back at the end and do some question and answer. But let's dive in to farmland leasing and other options for improving land access. As Wendy said, my name is Kelly Wilfert. I grew up on a farm in northeastern Wisconsin. We're about 700 acres where we raise fresh market fruits and vegetables, cash grain, and processing vegetables. My brother's in the process of taking over that operation. I still try to help out nights and weekends, but my expertise is really in farm and agricultural law. So I have a degree in agricultural economics, focusing on financial management of farms, and then followed up with a law degree before starting in private practice. Bounced around in private practice from the ag banking industry, I should say, to just generally advising farms. And then in August, I was able to join the University of Wisconsin-Madison Division of Extension. With Extension, I am a farm management outreach specialist. So I have a statewide role where I talk about legal risk on Wisconsin farms. So you might see me talking about contracts or due diligence, analyzing new opportunities, farm succession, or of course, like we're doing today, a little bit on leasing and acquiring land. The one disclaimer that I do have to make is that the presentation is for educational purposes only. I always boil this down to, I am a lawyer, but I'm not your lawyer. So I'll give you some general information about farmland leasing law, but we don't have an attorney-client relationship, and you should not use this as a substitute for legal advice about your particular situation. All right, now that the disclaimers are out of the way, let's jump in. So why is farmland access important to your operation? Think about that for a second. Why do you need that land? Well, maybe it seems clear. If we don't have land, we're not able to grow crops. We don't have places to keep animals. We maybe don't have as much collateral to borrow against to finance expansions. Farmland access is a really big part of our operations. The three things that I'm going to propose that we'll talk about today: stability, flexibility, and profitability. Having a land base is going to help your operation be more stable from year to year because you know exactly what land you're going to be operating on. You're still going to have a little bit more flexibility. The more control that you have of that land, the better you're going to be able to pivot. And finally, profitability. If you know what to expect from that land, what the cost is going to be from year to year, you can create better efficiencies in your farm or on your farm. So keep those three things in mind: stability, flexibility, profitability. Let's talk about how big is leasing in Wisconsin. So not how important is farmland leasing just to your operation, but how important to Wisconsin agriculture generally. According to the National Agricultural Statistics Service, over 1/3 of farmland in Wisconsin is leased. So if we chop up the state, that's a pretty big chunk of farmland, which means that having stable leasing situations in Wisconsin is not only important to your individual operation, perhaps, but also important to agriculture as a whole here in Wisconsin. Circling back around, how do we do this, or how do we handle it on a farm by farm basis? Stability, flexibility, profitability. The first thing we're going to cover is that a verbal lease will not guarantee stability long term. We'll cover why in just a minute. Trust can impact the flexibility of your leasing situation. And I know it's a scary word, but negotiating a profitable lease doesn't have to be difficult. It can be as easy as a conversation where you're telling your story. So let's learn a little bit more about each of those key pieces of farmland leasing. The first thing we're going to start with is stability. Basic legal considerations for enforceable farmland leases. And what I want you to remember here is that a verbal lease is not going to guarantee stability long term. That being said, I recognize the reality that a lot of us who are farming have verbal leases. So how do we make sure that we protect ourselves if we're in that situation? We'll kick off with some basic legal considerations for farmland leasing. First thing I want to cover is enforceability. In Wisconsin, any contract for real estate, whether that's a sale or a lease, that is going to be for longer than 1 year has to be in writing. That's called the statute of frauds. And I've got the statute numbers on the screen there. You certainly don't need to pull them up, but if you're interested, feel free. But the statute of frauds says if you have a lease for more than 1 year, it has to be in writing or it's not enforceable. So let's talk about that. What has to be in writing for this to be an enforceable written lease? A written lease, the bare minimum that is required are that it includes beginning and end dates, a rental rate, a description of the property, and that can be whether that's a street address, a legal description, a tax ID number. There's some flexibility with what that description should be, but you have to be able to reasonably identify the property. The party names, so who owns the property, who's the landowner and who's the tenant. And then of course, because it's in writing, signatures that both folks agreed to it. As an attorney, I'm always going to tell you that a written lease is our best case scenario. It's going to give us the most clarity. Like I said, though, I recognize that not everyone has a written lease, and we have a lot of verbal leases here in Wisconsin. So what is the bare minimum that we have to have with a verbal lease? Beginning and end dates, still need that rental rate, that description of the property, and the agreement of both parties. Pretty similar if we're just looking at the bare minimum. If we think about how do we document a few more complex things, one of the best things you can do, whether you're in a written lease or a verbal lease, is make sure you document it. Again, get those party names, beginning and end dates, rent, any special terms that you've agreed to, whether that's about irrigation, tiling, nutrient management, conservation, or any other special practices that either you or the landowner is wanting to have occur on that property. And then whenever we are drafting a contractor agreement, begin with the end in mind. So when we are coming to an agreement, things are usually good between our landowner and our tenant. But we don't really need our contract until things start going wrong, right? When things are good, we don't worry about what the paper says. When we start to disagree, that's when we go back to he said, she said, or what the contract says. So this is where it's important, if you are documenting a written lease, think about what penalties are. So for example, what is a penalty versus what is a full breach of contract? And what are the consequences? Is it just a fine or a monetary penalty that you're paying to the landowner? Or does that landowner have the right to remove you from the land early? How can they terminate that lease? And when can they terminate that lease? When we're in writing, we get to help determine what those rules are from the get-go. And when I say we, I mean the landlord and the tenant. You have control of what's included in that agreement. However, if we switch back to enforceability and start thinking about verbal leases, what typically occurs or I shouldn't say typically, what occurs under Wisconsin law is that if you are in a verbal lease that goes for more than 1 year, so you are a year-to-year tenant, you are what is called a periodic tenant, which in Wisconsin, an agricultural tenancy is considered to be a year-to-year tenancy, a periodic tenancy. A periodic tenancy can be terminated by the landlord or by the tenant 90 days before the end of the term. So if your year-to-year runs January 1 to December 31st, then notice has to be given 90 days before December 31st that you won't be renewing for the next year. Where this gets a little tricky with verbal leases most commonly is that we maybe forget when that term runs from. Did it start January 1st or did it start March 1st? Did it start in April? When did it run? If we never had a written lease, we might have to use some context clues, but there could potentially be a dispute about when does that single year tenancy run? And so when does that 90-day notice have to be given? It's a big difference between finding out in October that you're not going to have a piece of land next year and maybe finding out in February that you're not going to have that piece of land for the upcoming year. So verbal leases do have that risk that if you are year to year in a verbal lease, you likely have a periodic tenancy that can be terminated with 90 days notice before the end of the term. If we think about real application of this, why is that a problem? Not only does it influence the stability of your operation, knowing if you've got land for the next year to raise feed or spread manure on, but it also can impact some of the crops that are planted on that land. So I saw some familiar faces joining. And so for those of you that don't know, my family raises strawberries. Strawberries are a perennial crop. So you plant them 1 year, and as they start growing, you actually pop the blossoms off of them so they don't produce fruit the first year. That allows their base to grow, and they become a little bit more, they become a larger plant, better root base, send more runners out, etc. They'll do better in future years. The second year is when we actually start harvesting, and that plant is typically going to stay in place for 5 or 6 years. Different farms have different approaches on that. We do about 5 to 6 years. If we plant strawberries, for example, on a piece of rented land 1 year, and it's a periodic tenancy, and at the end of that year, they decide that they don't want us there anymore, we've just made an investment into that crop that we're not going to see returned. You could use the same example looking at winter wheat or cover crops that you're planting prior to fall and keeping over the winter. You run the risk that you perhaps plant before they have to give you notice that your periodic tenancy is not going to be renewed. So what can you do? If you are in a verbal lease, one of the best things that you can do is just stay in contact with your landlord. Keep them updated and have conversations about what your plans are and why you may need that stability or written lease in order to recognize your investment from year to year. Again, I won't say that a written lease is not the best option because a written lease gives us the most certainty. But I recognize that if you do have a verbal lease, make sure that you are hitting those verbal lease requirements, beginning and end date, rent, description of the property, and everyone agrees. And I would really encourage you, make sure you document that beginning and end date. When did it start? Because 10 years down the road from now, you might not remember. And if we start disagreeing about when we have to give notice to terminate that periodic tenancy, you're going to want to have something to go back to and say, this is the date the lease started. The last piece that I have on here, we've talked a little bit about meeting the legal requirements for a lease. the statute of frauds, needing to have it in writing if it's more than 1 year, the periodic tenancy that results from having a verbal lease, and that risk that each year you potentially could have that tenancy terminated for the following year. The last thing on my list here for enforceability is the doctrine of emblements. And this is essentially legalese that covers what happens to crops that are not harvested by the end of the tenancy. So for example, we'll go back to our winter wheat example. You plant winter wheat in the summer, or summer, fall, depends on where you're at. It's going to grow over the fall, winter, spring seasons, and you're going to look at harvesting it the following year. If your tenancy ends in December, what happens to that crop? Who gets the wheat? Interestingly, Wisconsin does not have established case law on the doctrine of emblements like other states do. What I can tell you is that in other states, they differentiate between crops that are growing and are not matured and crops that are matured. So think, let's say field corn that is matured by the end of the year, but perhaps it's not harvested because of a wet fall or early winter. So in the corn situation where the crop is matured, it's considered owned by the tenant and they have the right to go get that property. However, in the case, I should back that up. It's not an absolute right. You still could potentially be liable for holding over and have to pay some extra rent or penalties. However, that matured crop is considered personal property, separate from the real estate that is owned by the tenant. On the flip side, if we talk about our winter wheat or our strawberries, which are considered a growing crop, they're part of the land at that point because they will not survive if they're removed from that property. The law is a little less clear there. Again, even in other states, typically that may go with the landlord. They may have to pay some penalties as far as the inputs, but they're going to maintain ownership of that crop. So that gets really tricky. Again, Wisconsin doesn't have established law on it. I'm talking specifically about what happens in some other states and what might influence Wisconsin law if it ever becomes an issue. But what you need to know is that there's a risk there anytime that your crops are staying on property past the termination date of a lease. And you really want to be thoughtful about, do you need a written lease if you're planting a crop that could be impacted like that on a piece of property, and or making sure you're having that conversation with your landlord so that everyone is on the same page. All right, so that was a lot on enforceability and how that helps provide a stable land base for your operation. The next piece that I'm going to talk about is the flexibility component. How can leasing help add flexibility to your leasing situation? And this is where I like to talk about trust. And you'll notice I have it in quotes because we're actually going to talk about the sometimes myth of trust. Very often when I talk to farm tenants, they say, I can't go ask my landlord for a written lease because they'll think I don't trust them. That, while it is a valid feeling that you're concerned about upsetting that partner, what we also have to think about is the situation for both the landlord and the tenant. Asking for a written lease is not a matter of trust. This is documenting a relationship that has perhaps worked well for decades, or a relationship that you're setting up for future success. You don't know what you don't know. We don't know what next year is going to bring, what new issues might occur. Having a written lease is going to help you try to think of what are all of those different things that could go wrong, and help the landlord and the tenant agree upon how those will be handled from the get-go. This is also really important for avoiding misunderstandings. not only do we have misunderstandings in actual misunderstandings of how two different people might interpret an agreement, we also sometimes have misunderstandings about how we remember what that agreement was. Has anyone ever had a memory where you tell the story and the other person looks at you and goes, well, that's not how that went. Or maybe you can think of doing that to someone else. It's very easy for the human mind to change the story a little bit or misremember. Getting it down in paper is going to help avoid a lot of those misunderstandings. And that is part of the story that I would encourage you to present to landlords if you're approaching them for the first time asking for a written lease. It's not that you don't trust them or that you don't trust the relationship, but you want to make sure that you both are on the same page. And also talk about what happens if the landowner changes. So you'll notice I have it here, the changing landowner. Unfortunately, one of the truths of the human condition is that we all die someday. What happens if something happens to your landlord? Who takes over in their stead? Is it a spouse, a child, a niece, a nephew, a cousin, a brother? Do they sell it entirely? You might know that you can trust your current landowner, but if they step out and get hit by the proverbial bus tomorrow, who will you be working with? You might propose this to the landowner that you are not only protecting yourself, but you're also protecting their potential heir. If, for example, the person who may end up with that land does not have a farm background, or perhaps has a very different understanding of agriculture than the landowner themselves, they might have different requests or needs for how they expect the tenant to manage that land. Having this current agreements documented in writing is going to set guidelines for not only your current landowner and your current tenant, but future generations as children and heirs start to take over. So it protects both sides. And of course, that's why we again go back to document it. Getting it in writing helps avoid those misunderstandings. And it also is going to help you know, did the landowner change? Because that lease is between your current landlord and your current tenant, we now know if we make a change in who is renting that property or leasing that property. For example, you might have a landlord that puts the property into an LLC or a trust. Well, once we update that party name, we're now aware that that has changed hands. It helps us all stay aware of the evolving situation. Document, document, document. And this is where I always say too, even if you can't get a signed written lease, make some notes for yourself about what that conversation looked like, so that you know what your understanding was at the time that you made the agreement. So we've talked about stability and how to make sure your lease is enforceable so that you have stability. Talked about how actually documenting it can provide increased flexibility for your farm because you know what those changes are and when they're coming. The third piece we'll talk about is how negotiating a profitable lease doesn't have to be difficult. So I know when I say negotiation, everyone goes, ooh, because it sounds like a very adversarial process. It sounds like something a lawyer would say, right? Let's get to the table, let's negotiate. But negotiation doesn't have to be this one-on-one hard process. It can be as easy as just continuing to have conversations. How many of us as farm tenants talk to our landlord every year, even if it's just once a year? You go in, you drop off the rent check, you sit down at the kitchen table and you say, well, how's the family? How was the year? How is this person doing? That conversation can be part of your negotiation. You want to ask your landowner, how did they think the year went? Was there anything they weren't comfortable with? Learn about their family situation. Are their children coming back? Are they thinking about passing the land on? You might not want to necessarily ask them these things outright, but listen to what they're telling you as you ask them how they're doing and how they felt the year went, and you might learn more than you think. At the same time, you want to tell your story. Have a conversation, talk about the farm and the people that are involved. For example, if you are an older farm tenant and you are working on farm succession, maybe you're going to start talking about your successor who's going to take over. Talk about the management decisions that they're starting to make and how you're involving them in the farm. Maybe bring them along with you and introduce them so that if you're looking at transferring the lease into their name in future years, you start to build that relationship. You might also talk about your farming philosophy and practices. Maybe you are trying a new irrigation method. Maybe you've adopted some new conservation practices. Talk to your landlord about that and let them know what are your values in your farm operation. Try to match those up with the values that they're talking about in their needs and wants. Let them know how your partnership uses their land to meet both of your goals. I would also say don't be afraid to talk about the goals of the operation. What does the future look like for your farm? And really, how does the land fit into the picture? Again, are you really excited about the conservation practices that you've implemented? Maybe you're really proud of the nutrient management plan that you have on the property. Or maybe you just want to talk about your overall land base and how the farm is doing. Much like when we are connecting with consumers and telling your story about why you farm, it can be very valuable to do that with your landlord as well. Help them feel like they are part of the operation and let them know how much you value having that land. And again, my favorite slide, document, document, document. If you're making changes or you've had this conversation and you think you two have reached an agreement, don't be afraid to say, hey, can I put it down in writing? I was really excited that we talked about, and again, conservation is a common value. So I'll use conservation as my example. I was really excited we talked about the conservation practices. Do you mind if I put them down in writing and you take a look at it to make sure that we're both on the same page about what's going to happen with this property? I do, as a lawyer, always caution you that you want to be careful about how specific you get. It's good to be specific, but also make sure that you are reasonable. So make sure that if we are maybe measuring soil fertility or taking soil samples, be thoughtful around what is going to be lab error if there are changes in soil fertility. Don't say it's not going to change at all if there's a potential that it's going to change by, again, lab error or a small acceptable amount. Be very reasonable in including an actual range rather than a specific number and saying it's not going to change at all, because what's in writing is what gets enforced. You might also want to think about including, if we talked about implementing a certain conservation practice, maybe there's a weather event or another change in the farm that is going to cause you not to be able to do that. Again, think about what the consequences are. Is it a penalty of some sort, or is there some flexibility to simply adopt? We can draft up, I shouldn't say we, but your lawyer can draft up a provision that helps to identify where those changes might be and allow you to flex. So again, my key pieces when we talk about leasing. Leases are such an important part of Wisconsin agriculture, again, representing over 1/3 of the land that is farmed in Wisconsin. But making sure that we have appropriate leases in place is really key for your farm operation stability, flexibility, and profitability. A verbal lease on its own is not going to guarantee stability long-term. But if you are using a verbal lease, at least make sure you're documenting those requirements, and especially the beginning and the end dates of each term. Trust can impact the flexibility of your leasing situation, but don't be afraid to have a conversation while you have that relationship and explain how getting something in writing can actually benefit both the landlord and the tenant. And finally, don't be afraid of negotiation. It doesn't have to be adversarial and can be as easy as a conversation each year where you tell your story about your farm operation. Changing tax a little bit, we'll jump from leasing to land transfer more generally. I'm just checking the time. We're about noon. So about a half an hour in, about a half an hour to go. What are some other ways that you can access farmland? Let's talk about the state of land transfer in the United States right now. The United States Department of Agriculture, USDA, released a study back in 2019. Actually 2014, excuse me, the numbers are 2019. 2014, that from 2015 to 2019, about 9% of farmland in the Midwest was expected to change ownership. 9%. That's almost 1 out of every 10 fields was expected to change ownership from 15 to 19. We're expecting updated numbers coming out this fall. I will try to keep folks posted on that when it does come out. I'm hoping maybe they'll tell us how much land actually changed hands. And then again, how much is expected to change hands in the next 5 years. But let's go back to 2014. What did they think was going to happen? About 9% was going to change ownership. And of that 9%, they said about 23% of landowners expected that they would be selling that property to non-relatives. About 14% expected that they would be selling their farmland to another relative. And 63% said that they would be transferring that land between 2015 and 2019 through a gift, a trust, or a will. So what does that tell us? When I look at those numbers, the big takeaway that I see is that the majority of our farmland is changing hands through farm succession. Over 75% is going to be a sale between relatives or a gift, a trust, or a will, which I think we can probably pretty safely assume will typically keep it in the family as well. So the old adage that you either marry it or inherit it still does ring true, which makes land access very important for our beginning farmers and folks that are interested in expanding. I did throw in here as well, again, the average age continues to rise, which really does hit home that farm succession continues to be a major topic when we start talking about farmland access. Let's talk a little bit about some of the ways that land transfers and what the consequences might be. As I had mentioned, sale, gift, or I'll say inheritance to sort of wrap up trusts or wills. Sale, gift, or inheritance, those are the 3 ways that we see land transfer. What do we think about when we're trying to choose between those transfer mechanisms? So of course, and not on this slide, but of course, one of the things that's being considered is what does the current owner generation of that land need to get out of it? Do they need to get paid for that property? Do they have a successor identified? And if they do, how are they choosing between these 3 choices? If you are the buyer or the recipient of the land, what you potentially care about is not only getting that land and being able to use it for both farming and possibly for borrowing purposes. You also want to think about basis. So basis is your tax basis in a property. If you acquire a property by sale, it's going to be approximately the value that you paid for that land. If you're receiving it by gift, you are taking the giver or the donor's basis in the land. And if you're getting it by inheritance, depending on the transfer mechanism, in general, if we're getting it through, say, a will, you're going to get that step up in basis to fair market value. So let's talk about how this works. I had a perfect example in a farm succession presentation last week, where a gentleman mentioned that his father had purchased land with about at $3 back in the 50s, $3 an acre. So his basis in the land was $3. Today, he estimated that that land was valued at about $8,000 an acre. His father's basis was $3, but if he sold it today at $8,000, he would potentially be paying capital gains tax on the difference. So that sale price minus basis equals the gain, which is then subject to tax. So in that instance, it would be $7,997 that would potentially be subject to tax. If he sold it, the individual who purchased it would take basis at that sales price. And the current owner, who's the seller, would pay tax on that gain. If instead he chose to give that land to, say, his son would then take that $3 basis and be in the same situation. If he went through a will inheritance situation or intestate inheritance situation, the person who received it would end up getting that step up in basis to fair market value to that $8,000. And if they sold it tomorrow for $8,000, their sale price of $8,000 minus their basis of $8,000, they wouldn't have any gain, which is subject to tax. This is where farm succession can be incredibly key to farmland access and the flexibility in what you're doing with that land. I do sometimes have successor generations that say to me, I don't care about basis. I'm never going to sell this property. I'm going to keep farming. I would like my parents to just give me the land. I'll take their low basis and it doesn't matter because I'm not going to sell. And while I respect the feeling that is there, and some folks will choose to go that route, there's also a risk. Like we talked about earlier, you don't know what you don't know. What happens if the person who has been given that land passes away and there's not a successor who's planning to farm? Granted, at that point, their spouse is probably going to get the step up in basis and be able to sell without a gain. However, what if that person is in a farm accident and is disabled, but not killed? Not that we want to say that dying would be preferable, but unfortunately in that situation, they wouldn't get the step up in basis. That would mean you'd now be holding land that you aren't farming or maybe aren't able to farm, and you maybe can't sell if you are concerned about paying the capital gains tax on it. Or you're forced to sell it and you do have to pay that gain on it. You might be better setting up that next generation if you're able to think about how you get that step up in basis. But again, we also recognize that this causes challenges for the successor generation who is perhaps looking to expand or borrow against that land in the years prior to the current owner's death. In short, it's a complicated decision to make, but something that you should certainly be aware of because it does impact the decisions that you potentially can make with that land down the road. So why did we start here? Basis is something that gets a lot of discussion when we talk about the options for transfer. So I wanted to give you a background in that. Let's now talk about, we know how gifts work. We sort of know how inheritance works. And if you're interested in learning more, join me for one of my farm succession presentations and we can talk about that further. But let's also talk about a sale or a purchase. What are some of the options for buying land here in Wisconsin? So I'm going to talk about this from the perspective of structuring a purchase. So how might we set this up? You might have an outright sale, which is going to mean that title to the property is going to transfer as of the date of closing. You are either going to have that cash available, which you've got that cash available right now while you're farming. You let me know, because that's impressive. But more than likely, with the prices that farmland is at, you're probably going to be looking at financing that purchase. When you're financing, that financial institution, whether it is a bank or farm credit, is going to be asking for a promissory note that says, I agree to pay back X number of dollars with interest. A mortgage, which uses that land as collateral for the promissory note. So if you stop paying the promissory note, they can go back and take the land, foreclose on the land. And then possibly you'll be asked to sign a personal guarantee. A personal guarantee pledges your other assets in order to pay that debt. So again, if you're looking at an outright sale, you're probably going to be looking at financing, be asked to sign a few more legal documents as you keep paying, and the tax consequences. That seller is going to have an immediate gain equal to that price minus the basis, and the buyer is going to have basis equal to the price paid for the property. So that's one option, an outright sale. Another option you might be looking at is an installment sale. An installment sale spreads out the payments over a period of time. This has some benefits to it and some risks. If you are the seller, you are not receiving that lump sum of money up front, which means you're taking a risk that the buyer might fail to pay you down the road. They might not make as much money as they need to actually pay what they owe you. That being said, you may then want to play the role of the bank and think about, do you have not only a promissory note, but do you also have that mortgage or other collateral to support your essentially your loan or your delayed payments? The tax consequences, the seller is still going to have a gain equal to the price minus basis, but that gain is going to be spread out over the term that the sale is spread out. And again, the buyer is still going to have basis equal to the final price paid for the property. One other thing to keep in mind is that if you are not including an interest rate or an interest rate that the IRS deems appropriate or high enough, a portion of the payment might be reclassified as interest income to the seller, or an additional dollar amount might be added and classified as a gift to the buyer. So two potential consequences there. This is going to be fairly similar to a land contract. A land contract is a specific type of installment sale. The Wisconsin Realtors Association has a specific form that is standard in the state of Wisconsin for land contracts. And it essentially acts as both your promissory note and your mortgage if you are the seller. It's seller financed. So again, if you're the seller, just like the installment sale, you're not getting your money right up front. You're not transferring full title right away. But the buyer has everything but that legal title. They have the right to occupy the land, use the land. The risk here, if you're the seller, is again that the buyer perhaps doesn't pay you and you end up with the property back. For the buyer, land contracts in Wisconsin, the standard terminology that is on them, and in theory could be edited, but is standard, is that if you default and the property goes back to the seller, you not only lose the property, but you also lose your equity in that property. So as opposed to a foreclosure, where your debt is paid off and you might receive some of the proceeds back, with a land contract foreclosure, your equity goes back to the seller. Your tax consequences are similar to an installment sale. But again, we covered sales a little bit there, but the bigger issue really is most of our land transfer is happening either a sale between relatives or gifts, trust, or wills. So one more time, I will hammer home the importance of farm succession if we're talking about farmland access. Big takeaways for today. Improving your leases can improve the stability, flexibility, and profitability of your farm, but make sure that your leases meet all legal requirements to be enforceable. Negotiation doesn't have to be adversarial. It can just be that conversation at the kitchen counter. And fun fact, you don't even have to tell the landlord that you're negotiating. You're just having a conversation. Finally, land transfer options are available, but as most of us know, the price of farmland right now is very high. Third time I can say it, I think, because the majority of farmland is expected to transfer through gifts, trusts, and wills. Farm succession and estate planning are really important keys to that future generation's success on the farm. If you're interested in learning more, I had mentioned earlier, I am part of the farm management team at the Division of Extension. If you go to our website, farms.extension.wisc.edu, one of the topics that's available is ag land pricing and contracts. We have a number of resources there that talk about different types of leases. So whether that is a straight cash lease, whether that is a crop share, or some sort of flex cash lease that is in the middle. We have resources there to learn about those, to learn about equipment leases. We've got the average rental rate by county there. But one piece I will caution you, when you look at the average rental rate for your county, think about what other terms are going into that. While it's presented by, I believe it's Ag Statistics Service again, as strictly a flat cash value, you also want to think about what other terms might be changing that dollar amount. Are perhaps more terms around conservation or nutrient management being exchanged for a lower rental rate? Or on the flip side, is someone paying a higher rental rate because they have very minimal restrictions? The number doesn't always tell the full story. But again, those statistics are available at that link. Also at that link, we have 3 videos that were done over earlier in this year about protecting your farm from the risks of a verbal farmland lease, leveling up your Wisconsin farmland lease, which if you were interested in the legal requirements that I talked about earlier, you can find them again in this video. And then my colleague Steve Okonik also did a soil and water conservation clause video talking about some of the clauses you might include in your farmland lease. With that, I think we are probably a little early, but that gives us some time for questions. And again, that link to our website is farms.extension.wisc.edu. I will stop sharing. And again, happy to take any questions.
Feel free to just unmute yourself to ask your question, or if you want to put it in the chat, you can do that too.
I'll start. Kelly, do you meet with individual farm seekers and landowners to help people through this process?
So that's a tricky question in ways. So I do answer a fair number of questions for landlords, tenants, interested tenants to talk about the resources that we have online. Because I am an attorney, I have to be a little careful with the line of I can't give legal advice. So I don't look at documents for people. And I can't tell you, you know, what's maybe a good clause or a bad clause. But happy to have conversations when there are questions on some of the legal issues. So for example, I get a lot of questions on termination, a lot of questions on that doctrine of emblements, what crops can be harvested and how after the termination of the lease. Yeah. Does that sort of answer your question?
Yeah. Yeah.
Okay. Other questions that I can answer?
Hey, Kelly, Dan and Becky Meyer here. Some of the things you shared, kind of funny. People don't like talking about legal stuff. They don't like talking about death. They don't like talking about taxes. We try to avoid all those things in our life. But literally the first time the step up in basis conversation happened with me was a couple of months ago on vacation with a guy from North Dakota. Like, we don't talk about these things nearly enough. Is there a timeline to that? Because literally my dad died last year and you can't get the appraisers right away, all that stuff. What does that look like? Or is it a due diligence kind of thing? Or what is the requirement there for step up in basis timing?
Yeah, step up in basis is considered to be either at the time of that individual's death, or now I have to think if it's 6 or 8 months out. I can get you the answer on that, Dan. There certainly is sort of an understanding that appraisals can take time. So I wouldn't be overly concerned about it as long as you are working towards that process.
And the other thing that really surprised me, the attorneys were kind of like, hey, just back off and don't be in any rush to do anything, like, get through the tax year kind of thing. It was really odd. Like, for me, I've heard the opposite, where the attorney just takes over and sends out all the death certificates. So every attorney has their own way, I guess, but just strange. Just two opposite sides of the field from two pretty professional attorneys based upon Becky's mom's dying and my dad. It was just really strange.
Yeah, different attorneys will have different approaches. It also will depend on what that individual's estate plan looks like. So farming being very unique in that as well, because we know that we have businesses that are continuing to operate during that tax year. So depending on how the estate plan is set up, there may be reasons for trying to keep income, for example, in the estate through the end of the tax year, as opposed to trying to make that transition and have the income going sort of directly to the heirs and being taxed at the heir or beneficiary's tax rate, because you've transferred it very quickly.
Kelly, this is Dave Daniels. You talked a little bit about it, installment sale, and you mentioned something about interest and gifting interest. Could you go back to that slide by chance, and then also touch on the minimum required interest that would be used for either installment sale or land contract, or if there's any difference?
Absolutely. So I'm going to pull a slide. You're gonna have to tell me if I'm, oopsie daisy, if I picked the right one or not. Let me see. Is that this one?
Yes, that would be the.
Okay. Okay, certainly. And then I caught the question about interest rate, so I'll answer that one first, and then you might have to remind me what your other question was.
Okay.
So when we talk about interest rate, the IRS identifies an applicable federal rate each year that is considered, and I don't have the perfect legal term for it, but what I'll call an appropriate interest rate for an arm's length transaction. Essentially, they will say if you are perhaps doing an installment sale or a land contract and you're not charging any rate of interest, that's not reasonable, right? Because we're seeing potential appreciation, You know, and if you were paying completely a third party, you would be required to have some interest rate included in there. So what they do is they'll look at that applicable federal rate table that they say is these minimum interest rate. And if you don't have an interest rate included in your promissory note, your installment sale, they might recharacterize part of the payment as interest based on that interest rate. And what that can do is potentially change the tax implications from interest income, which is going to be just your standard income tax, as opposed to your capital gain, that is the portion for the actual property that's being paid. That being said, in some situations, they might also argue that an additional dollar amount should be allocated for interest, and that, again, typically if you have a family relationship, maybe you are actually making a gift. You're not charging interest because you're gifting that interest rate to that next owner. And that can impact your unified estate and gift tax credit. So each year, every individual has $18,000 that they can gift. If that interest for that year would cross that $18,000, potentially it starts going against your unified estate and gift tax credit, which is for 2024, you can pass $13.61 million at the time of your death through your estate. But that also covers lifetime gifts. So now that's a little bit of a maze to wade through. Sort of the big thing to keep in mind is that whenever we are handling transactions between related parties, family members, specifically when it's lineal, so like parents to children, you're going to want to think about having someone check that rate.
Yeah, the other question was whether, is there a difference on minimum interest on the installment sale or the land contract? Is there any difference?
I would say no. The IRS is still going to look at that applicable federal rate in either situation.
Okay, thanks.
Which is, it's just the table every year that you pull from. Brandon, you asked this presentation will be shared. Yes, my understanding is Wendy is recording and we'll share it with folks that registered. I also saw Mark Schmitz from DATCAP's Farm Center dropped that applicable federal rate table in for me into the chat. So Dave or anyone else, if you're looking for that, definitely click on that link. Thanks, Mark.
All right. Do we have any other questions for Kelly before we sign off?
Before we do, I'll also mention the other comment that Mark put in there. One of the challenges in this short presentation is I don't always get to cover all of the exemptions. So Mark does have the exemption on capital gains based on your taxable income too. Thanks, Mark. Mark is also a great resource. Both Extension, we're happy to answer questions, and the Farm Center too. So don't hesitate to reach out.
Yes, if you are unfamiliar with the Farm Center, I would definitely check them out. They can provide a lot of great resources for you as well. And maybe that could be a whole other lunch and learn is that topic in itself. So thanks for joining us today, Kelly. We really appreciate it. I thought you provided some really valuable information. One of the things that really stuck out with me are those verbal agreements and how you yourself might be that trusting person who's like, oh, nothing will ever happen to this, but there might be a change in family and things, and then those things go to the wayside and you're kind of stuck. So thank you so much for sharing that. And thank you to everyone for joining us today. We're glad that you could be here. Don't forget to join us for our next Lunch and Learn, which will take place on the first Wednesday in May. And in May, we will be sharing resources related to farmer mental health. So we'll be hearing from the Wisconsin Farm Center and their Farmer Wellness Program, together all a new resource from the Farm Foundation and American Farm Bureau, and then also Farm Rescue. So thank you again all for joining, and we will see you soon.